one of the common questions that we get asked is whether a grant of probate is always necessary, especially if the estate is small or the parent had no will at all. And the answer can be quite nuanced. Many people believe that every death requires a grant of probate, which is not the case. Whether or not you need a grant of probate, which applies if there's a will, or a grant of letters of administration, if there is no will, generally depends on the nature of the estate assets. So when isn't it needed? Well, if the person only held assets jointly with another person, such as bank accounts or real estate held as joint tenants, these automatically pass to the surviving joint tenant by right of survivorship, and they bypass the estate entirely. In the case of small estates, banks, share registries, and other institutions often have a threshold, usually between $20,000 to $100,000, below which they'll release funds simply with a death certificate and a copy or a certified copy of the will. And they'll also usually require a signed indemnity from the executor, and they can release the funds without requiring a grant of probate. Another example is nominations dealing with the proceeds of a life insurance policy or a superannuation death benefit. Unless these are expressly payable to the estate pursuant to those nominations, then they go directly to the beneficiary and not to the estate, and a grant of probate wouldn't ordinarily be required to deal with those interests in property. So when is a probate actually needed? Well, if the deceased owned real estate solely in his or her name or as tenant in common with another person, or if the deceased held significant bank accounts or shareholdings above that institution's release threshold, then you will need a grant of probate to be able to deal with those assets. It's also worth noting that regardless of the size of the estate, obtaining probate also provides some legal protection to the executor when administering the estate in accordance with the probated will.